the National Assembly.
Yes, Your Lordship, my lords, on behalf of Senate, I will lead the team and will be on point. Will be assisted by two other counsel on other questions. Not more than 2 hours. I think I should take not more than 2.5 hours. I'm normally very brief.
My Lord, on behalf of Professor Kithure Kindiki, we also need 2 hours. We'll be sharing the time with the team that I lead.
On behalf of the Attorney General, I wish to confirm that we do not wish to make any further submissions, as we believe that our submissions were clear and nothing we have had since we made them has changed that position.
Your Lordship, if I may, on behalf of the ninth respondent, we require about 45 minutes.
My Lord, for the 10th respondent, we'll just do 1 hour.
Okay.
On the part of the commission, it will take about 20 minutes.
Which commission?
The IBC. The 16th respondent.
Lord, may I suggest that perhaps we start with the IBC, which is taking 20 minutes, and then we come to the parties who wish to take longer. And also wonder why my learned friend Dr. Thiankulu would require the same amount of time as the primary respondents. He is really an interesting
I think those submissions were being made on the light of the knowledge that I divided by half. I will certainly will not give you 2 hours. I'll not give you 2 hours. I'll not give you 2.5 hours. But will give you sufficient time for you to make coherent submissions in this matter.
Our only concern is parity of arms. That side took about 10 hours. 10 hours. So we'll be taking less, even if you add all the times that they took. Yeah, even when you subtract the half, they still took 10 hours.
They did not, but we'll give you sufficient time.
My Lord, for the record, for the Speaker, my Lord, Milimo, my Lord will be taking not more than 30 minutes.
That's 15, that's good. So can we have the person who will set the pace, 10 minutes, IEBC?
If it may please you, my Lord, my name is Kibe Mungai. I appear with Mr. Kamwaro and Mr. Peter Koira for the 10th to 41st petitioners. We made our submissions on our petition last Thursday. My Lord, we are here for the simple reason that the following day, on Friday, the Constitutional Court of South Africa rendered a decision with regard to an issue of presidential impeachment that directly deals with part of the issues that was substantially raised on behalf of the first petitioner and by the 10th to 41st petitioners. A judgment that is directly relevant in this matter. Being proactive, yesterday, the 12th of May, we filed supplementary submissions to bring, which we have served all the parties, to bring that issue to the attention of the court, and with a view that the supplementary submissions that we did, the court may certify them as duly filed so that they become part of the record of our submissions, and today, so that to enable the other side to respond, to be able to seek directions of the court on how we should progress based on that issue. We make this request for the simple reason that the Supreme Court, in the case of Sonko, that has been cited severally, indicated that the advocates and all the parties and the court have a responsibility to ensure that cases are decided on the basis of all relevant matters of law and fact and the best research that is possible. So we are under our duty, and we have done something direct, proactively, to certify that duty, that this is a decision that needs to be considered by this court. And the right procedure, if I may be asked, is that I would be requesting that within 30 minutes, I can formally, before they start, because it is a matter they would have a right to respond to summarize what are the issues and brief reasons why that decision should be incorporated and the sense in which it should be understood by this court as part of the petitioner's submissions. I believe in particular the first petitioner, whom Mr. Ochier said a lot of things about that issue of the Senate and the special committee, would have an interest in that particular matter. So may I request for directions on that issue. It is already filed, the decision is also filed, so that all that would be required would be to hear what would be the best way to proceed before the respondents have started. I believe, in view of the proceedings that have taken place, the petitioners have just closed their case for today. Only that my learned colleague, Professor Muigai, had made submissions on behalf of the client Attorney General. So that's all my question.
My lords, we became aware of this decision as soon as it was issued, and this is largely due to my younger learned friend who circulated it, and for which I thank him. It's a very weighted decision from the Constitutional Court of South Africa. It will be our submission. It is totally irrelevant. What I would propose we do, just like my learned friend Mr. Kibe Mungai has done, he has filed his own submissions on it. I would beseech my Lord to open the same path to anybody who wants to submit on it, and we leave it at that. We do not wish further time be expended on this is the court, this is the judgment of a foreign court about foreign law. So it should not detain us, and we should proceed as my Lord has suggested.
That's a sensible suggestion on our side. And we also think that the court can save time for rejoinder by allowing most of the petitioners to make their rejoinder in writing that way, and then the wish to conclude today could be achieved.
Mr. Kibe, you look...
It's just that it is irresistible for the first petitioner not to join issues, Professor Gidu Muigai, that this decision is utterly irrelevant.
It is?
He said, he told this court that the decision is utterly irrelevant.
I thought you were confirming that.
My concern is that there cannot be a more relevant decision on the attempt to avoid a committee of parliament to do the investigation, and on the jurisdiction of the court to question actions and decisions and resolutions of parliament. This decision answers to those two issues, but if everybody gets leave of this court to put in written admissions on that point, then I'm in agreement with senior counsel, Professor Gibu. Thank you.
I knew, my lords, one day before we retire, my learned friend and I will agree on something.
Thank you very much. I think we have more or less agreed that we treat Mr. Kibe's submissions on that issue. We allow parties for submissions on that issue. And between now and then, and the time we retire to write our ruling, if you have an authority, just file it. Just file it, we'll consider it.
Auditor, we shall say something about it during the rejoinder.
All right, that is okay.
Thank you.
Yes, IABC.
My Lord, we have Ms. Joy and Mr. Nura. I think the President called.
We will particularly take note of time.
If Your Lordship could give me a second to catch my breath. It's a hassle to get from the back of the court to the front. Pleases my lords, my lady. My name is Nura Abdul Kadir. I appear alongside Ms. Joy, Ms. Faith Kiende, Mr. Derek Asala, and I also hold brief on Mr. Mahar Somani for the 16th respondent to the IEBC. And together with these oral submissions that I will make, the 16th respondent also relies on the submissions he filed on the 25th of October 2024, 27th of October 2024, and the replying affidavit sworn by the then CEO, Mr. Marjan Hussein Marjan, sworn on the 25th, my Lord, of October 2024. We'll be relying on those documents, my Lord. We will briefly highlight on a single issue, my Lord and my lady. And that issue is the IEBC's involvement under Article 149 of the Constitution regarding vacancy of the office of the Deputy President. And the main question that we will be asking is whether the Constitution contemplates any role by the IEBC in the filling of that vacancy. My Lord, Article 49 identifies two actors expressly. That is the President and the National Assembly. Therefore, the question that arises for this court's determination is whether, beyond those two expressly identified individuals, those two expressly identified actors, does the Constitution intend any additional role for any other actor, but for purposes of this submission, the IEBC. My Lord, it is our humble submission that that particular article is deliberately narrow and precise by design. It provides two constitutional actors and two constitutional functions. First, the President, who nominates a person within 14 days. Second, the National Assembly. So on a plain reading, my Lord, of that article, the Constitution does not introduce any third actor, any intermediary, institution, or any additional clearance mechanism where IEBC would play any particular role. And my Lord, in answering this question, and because these submissions have been made severally before this honorable court, is what would have been or what could be the intentions of the drafters of the Constitution. And in asking ourselves this question, my Lord, we interrogated the harmonized draft and the Bomas draft 2004. Under Article 168 of the Bomas draft 2004, my Lord, the process was expressly confined to the President and Parliament. And while this process was a bit more complex than what we have in our present Constitution, involving both houses of Parliament, it still made no mention of the IEBC. When we move closer to the current Constitution that we have in the harmonized draft at Article 170, it is more similar to our Article 149. Again, there was absolutely no mention of any role played by the Electoral Commission at any point. Therefore, both drafts reveal that the drafters of the Constitution, sometimes we belabor too much on what the drafters intended. It could be easier to just reach out to Professor Gizmiga and ask him what he intended. But it is clear from those two drafts that there was no intention to involve the Electoral Commission. Therefore, we ask ourselves, where could the qualms and the quarrel by the petitioner have arisen against the IEBC? And that would fall on one article of the Constitution. That is Article 148, the qualifications of a Deputy President. If you look at the qualifications of a Deputy President under Article 148, the Constitution references you to the qualifications of a President in 137, which further references you to the qualifications of a Member of Parliament, which is Article 99. My Lord, it is our submission that the petitioners proceed from an assumption that the IEBC must therefore undertake a formal verification or a clearance exercise as though the filling of a vacancy under Article 145 were an electoral process, which we humbly submit that it was not. My Lord, it is our humble submission that if there is any role that is not expressly stated or implied under Article 149, it would be to the two actors who have been mentioned in that article. That would be the President and the National Assembly, to satisfy themselves that the nominee meets the constitutional requirements of that office. My Lord, in that context, and seemingly out of abundance of caution, that we submit that the President sought factual information from the IEBC. And the IEBC merely responded with information that was within its custody, whether or not an individual is within the voter register. My Lord, we submit that up to that point, up to the point that the IEBC provided that information, it was not under any constitutional obligation or duty under Article 149. It simply provided information that it possessed. Now, my Lord, the other qualm that the petitioners seem to have is whether the information issued by the IEBC was improperly provided by a commission which was not properly constituted. My Lord, I humbly submit that this particular issue has been heavily argued before courts, and there's several case law that demonstrate the roles played by the IEBC, either by the Secretariat or the Commission, or the Secretariat and the Commission. And we humbly submit one of those very important authorities, which can be found in our digest, is the presidential petition of 2022, E005, Raila Amolo Odinga and others versus the IEBC. My Lord, we submit that in that case, three distinct roles came out clearly. That the IEBC possesses a role where the Constitution references, or where the legislation references the Commission. It could mean the Commission and the Secretariat, as was elaborated in that case, with the issue of verification and tallying. So a reference to the Commission could mean the Commission and the Secretariat. The instruction is to the Commission, but the action is to be taken out or to be handled by the Secretariat. And that can be found on paragraph 46 of that decision. My Lord, the second role would be that if legislation or the Constitution references the Commission, it quite simply means the chairperson and the commissioners. And that role is reserved strictly for the chairperson and the commission. And the decision went on to note that there are such roles that can be taken or handled by the Secretariat, such as this one, can we submit. My Lord, from that precedent, two principles clearly emerge from this binding authority. Number one, the Commission acts institutionally, not through personal involvement of the commissioners, in every function. It doesn't act through the commissioners in every single function. And that the Secretariat performs the day-to-day administrative and technical functions. So, my Lord and my Lady, the act that is complained about involves no deliberate decision-making by the Commission. It do not require any decision-making by the Commission. It requires no policy formulation, no exercise of constitutional discretion. It was purely factual and database driven, involving retrieval of information held in the voter register, verification of that information, that indeed the individual whom you sought information from is a registered voter,